Tom.
Well, the issue has been before the Supreme Court already. The Supreme Court just recently struck down the Federal Defense of Marriage Act, which prohibited recognition of gay marriages in the states. And the Supreme Court does have this case before it that will be argued in April and probably decided, and certainly decided by the end of June. And this has been decided over and over again by at least 4 federal circuit courts that gay and lesbian citizens have a right under the 14th Amendment, just like the rest of us, to exercise their fundamental right to get married.
Thomas.
So, Ted, you talk about the 14th Amendment with the Equal Protection Clause. Do you think that we're basically going to be able to compare what we're seeing now, what the Supreme Court is doing, to what we witnessed in 1967 as a country with Loving versus Virginia, and that we've reached that point where we're actually going to have this case, the cases before the bench now, that will unlock the country and make a coast-to-coast federal safety zone for gay and lesbian couples? So, me being married in New York, if I travel to a state that doesn't recognize it, I'll finally be able to say I'm still married in that state.
Yes, you're absolutely right. In 1967, in Loving versus Virginia, the Supreme Court struck down the laws in Virginia and 16 other states that prohibited persons to get married to a person of another race. That made it that was a unanimous decision, and that it recognized a fundamental right under the United States Constitution for persons to get married. That was among 14 decisions that the Supreme Court has made over the years, recognizing a fundamental right to get married. And our gay and lesbian brothers and sisters simply want to exercise the same liberty and the same freedom that the rest of us have. Many of these people have been waiting for 20 or 30 years for the opportunity to get married.